Thank you for coming. This topic is one that people don't realize that they need to be paying attention to. And so when I gave it last year for the first time, I probably had 20 people lined up, maybe 25, to ask me questions afterwards, because they had no idea how important, especially the hold period ordinance issue is. So I'm going to present it to you as best I can. Both of these are maybe a little drier than some of the other topics, so I apologize for that. But with a smaller group, hopefully I'll be able to get through it pretty quickly with plenty of times for questions at the end. And if something is not making sense because we have such a small group here, feel free to raise your hand and tell me, like, I didn't follow that. Can you help me out? But so I have limited this to two so that we can kind of take a deeper dive into two ordinances that should matter to you. And how many people, just so I know, how many people in here are from Texas? The vast majority of you. Good. Who's not from Texas? And where are you guys from? Just shout it out. All right, so everywhere. I heard a little bit of everything, but the hold period ordinance I'm going to talk about it really matters for Texas people because of a Texas Supreme Court decision, but only one aspect of it is really a Texas-centered, but it's still, the whole thing still matters to everybody, and as I'll explain, you likely have a statute somewhat similar to Texas's that you have to deal with. Okay, so we're just going to go into these two types of ordinances today, the hold period ordinance and a rescue access ordinance. The first is rescue access. By the way, I took this picture myself. It's one of the coolest things, I've ever done in animal welfare, which was Bastrop, which is a town outside of Austin. The whole city was on fire. Like, it was astonishing and frightening. It was hundreds and hundreds of acres were on fire. And the animal shelter still had animals in the shelter. So in the middle of the night, communication went out to Austin Pets Alive Volunteers, which was a young organization at the time, much younger organization, and said, can you guys get here at 2 o'clock in the morning because we're going to get fire animals. And so they sent about 10 people with their SUVs into the fire, not literally, but into the city that was on fire. They loaded them up, every single dog that was left. Other rescues had already kind of picked over, and so they just grabbed what was left. And their temporary shelter that they were in at the time was full. So basically volunteers had to come in and take out all of the dogs and cats that were in their shelter to make room for all of the dogs and cats that they were bringing in the middle of the night. I think this was like 2 a.m. in the middle of the night, and the parking lot was crowded with people. We had hundreds of people there. We had lines of people to save the animals. It was pretty amazing that in the middle of the night they were able to do something so cool for animals. And I love that photo. I don't know why, but it always brings me back to that. So what is a rescue access law? It's a law that guarantees a qualified rescue organization a right to rescue animals that the animal shelter plans to kill. And I heard you say California, right? So you already have one of these laws. But California and now Delaware are the two states that have them, and now a number of municipalities have them, and Austin does too. You might be wondering why. Why do we need a statute that kind of mandates collaboration? And that's because not every animal shelter collaborates with rescue groups. Some of them make it very difficult to collaborate with rescue groups. Some of them use the ability to rescue as a weapon to prevent you from criticizing them, or from going public with information that you have, or from asking for changes. And so what this does is kind of A, it mandates the collaboration so that they are forced to work with rescue groups, and B, it prevents them from retaliating against a rescue group who speaks out against something at the animal shelter. In a New York survey, 71% of rescue groups had a shelter refuse to transfer an animal to them, and then the animal shelter killed the animal anyway. I don't know if it's worse, but it's also horrible. 43% of rescue groups had been retaliated against for speaking out against inhumane conditions at a shelter. And this was the one that really upset me. 52% of rescue groups reported witnessing inhumane conditions at animal shelters and not saying anything out of fear that they would lose their privileges to rescue at the shelter. So we are allowing inhumane conditions to continue at animal shelters because the very people who have the ability, who have the knowledge of what's going on at animal shelters are silenced because they don't want to lose the ability to rescue. Rescue access laws, however, have now been proven to save money. The No Kill Advocacy Center estimated that the passage of the law in California saves at least $1.8 million a year. The city of San Francisco alone calculated that that the rescue access law in California saves $500,000 annually. And they also save lives. In California, again, passage of the law has been followed by an increase of 370% in transfers to rescues, the difference between 12,000 in 1997 and 59,000 in 2010. So they do, in fact, save lives. Well, what do you need? What does a rescue access law look like? Well, you need you need a rescue right, some right that guarantees the rescue group and the access to the animals who are scheduled to be killed. 2, a notice of that right, so they have to be put on notice, this is going to happen. And what this does is essentially forces the shelter to create a euthanasia list in advance. And that was a huge fight here in Austin back in the day. The shelter did not want to give us a euthanasia list. And you probably have worked with shelters who don't want to give it either. They just say, come take whatever you want. We don't want to tell you. But if you're like Austin Pets Alive, what you wanted to do was save the ones that no one else was saving, right? That's the ones worth saving, the ones that are going to be killed. And how does it help you if you don't know which ones are going to be killed? So it kind of it forces the shelter to put together a list of the animals that it plans to euthanize. There are 2 important exclusions. One is to exclude certain types of animals that perhaps as a matter of public policy you do not want to be as part of the guaranteed rescue right. And 2, you probably as a matter of public policy want to exclude certain rescue groups. Those are matters of public policy for you to decide in your community. And I would encourage you to have, especially if you're a private shelter, a liability waiver so that any animal that goes through this does not subject the shelter to liability. This is language from the No Kill Advocacy Center's model rescue right, which is that no animal in the care or custody of a shelter shall be destroyed if, prior to the killing of that animal, a nonprofit animal rescue organization requests possession of the animal. So that one is very, very simple and short. Basically says that as a matter of law, you can't kill unless if there's a rescue group who wants it. I talked about safeguards. So you want to have, for example, an exclusion of organizations that if you have reason to believe that an organization has harmed animals in the past, obviously you want to exclude them. So one way to do that is to exclude organizations that have an officer or a board member who's been convicted of an animal-related crime, or if those charges are pending. Probably don't want an investigation because at any point the animal shelter a lot of times is the investigator, and if they want to retaliate against a rescue group, they could simply say, well, that rescue group's under investigation. We're investigating them, and they would automatically be excluded. 501c3s, if you've been to my other sessions, I always encourage animal rescue groups to be 501c3s. I think it helps professionalize the organization and also allows your donors to deduct from their donations from their taxes. And a lot of these model rescue rights and the ones, access laws and the ones that I suggest do exclude dogs that are particularly prone to dangerousness. And the language that I've kind of settled on is excluding dogs with severe unprovoked bite histories. So here is the one that we just got passed in Austin. And by the way, both this statute, all the statutes that I'm going to show you should be linked to my presentation in the app. Okay, so it's all there for you. You don't have to worry so much about making sure you get every word. But this is the one that we just passed in Austin. Not less than 2 business days, I'm not sure if you can read it, so I'll read it and we'll walk through it. Not less than 2 business days before euthanasia of any animal, the city animal shelter must notify or make a reasonable attempt to notify by verifiable documented communication, so they have to prove they did it, or be able to prove they did it, any rescue organization that has previously requested to be notified before the animals are euthanized. 2, unless there is evidence of neglect or animal cruelty as certified in writing by a licensed veterinarian, notify or make a reasonable attempt to notify the owner who surrendered the animal prior to its euthanasia. And 3, notify or make a reasonable attempt to notify the surrenderer if it's a surrenderer of a stray animal. So basically, this kind of creates a checklist that the shelter has to go through before they euthanize an animal. They have to make sure that the rescue groups who have requested notice don't want it. They have to make sure that the owner who surrendered it doesn't want it back, and oftentimes they do. Oftentimes, even if you warn them in advance, people who surrender their animals believe that their animal is special and will be adopted, and they can't even fathom the idea. And let's be honest, part of that's on us, because as an animal welfare community, we have encouraged people to surrender their pets. And when we see them face to face, we often say things like, we're going to do everything we can to get your animal adopted. And because of that, they assume their animal, in fact, will be adopted. So this gives a checklist to the shelter. First, you got to make sure that there's not a rescue organization. You also have to make sure that the owner doesn't want it back, or the finder of the animal if it was a stray. And 4, give one of the rescue organizations, should there be one, or under subsections 1, 2, or 3, possession of the animal to avoid its death if the rescue organization or person requests it. So it's pretty simple. I mean, I know it's wordy, but it's pretty simple. Basically, there is a right to rescue an animal that the shelter plans to euthanize. But we also do have, and then of course there's the kind of enforcement mechanism. The city shelter may not euthanize any animal without making the notification required by the subsections. And then there are the exclusions that I talked about that are kind of safeguards, both for the community and for the animals. It says this section does not apply to an animal who is irremediably suffering. Meaning, if an animal is truly suffering and needs to be euthanized, it's not the statute does not apply to that animal. We want to allow true euthanasia. We just want to get euthanasia back to its true definition. And killing a healthy animal is not euthanasia. It's just not. Euthanasia is killing an animal, is taking the life or ending the suffering of an animal who is truly suffering. It also doesn't apply to a dog whose release to a rescue organization would violate a court order, and that was because, of course, there are dangerous dog ordinances and statutes, and there are times when a court has declared a dog dangerous and ordered its death. So we had to exclude that. And this was probably the most controversial part of it, which was exclude a dog with a documented history of unprovoked biting that has resulted in severe injury to a person. It was controversial on both sides. The shelters, I think the shelter side and the people who don't like the no-kill movement argued that this forced the shelter to, the exclusion wasn't big enough, that the shelter should be able to remove from the rescue right a larger number of animals. And even now, I think there's going to be a push in Austin to expand 3 so that the shelter has more authority to decide what animals can or cannot be rescued. But we were also criticized, also controversial from the other side, which is the rescue groups, and some of whom don't believe that the shelter should ever be able to decide that an animal is too dangerous to be rescued out. And so we couldn't please anybody. That was impossible. And so we tried to do what we believed was right, to have a fine line. One of the problems that we had in Austin, and it's really fascinating, it'll probably happen in your community as you reduce the number of euthanasias, is we went from a community that was literally killing, I think, 14,305 animals in 2005, I believe is the year. 14,000. Last year it was less than 1 a day. So we went from 34 a day to less than 1 a day in a matter of a decade. And because we euthanize so few animals now in Austin, the volunteers get to know them. They know the dogs. They know them. It's not like 30 are getting euthanized that day, right? Where they're coming in and going out. Coming in, staying the hold period, and going out. They get to know them. And sometimes the behavior doesn't get seen until they're at the shelter, right? They don't have bad notes when they come in, but the shelter decides. So one of the things that happens is that people really get to know them. And because people really get to know them, there are fights over those euthanasia decisions. Big fights. And I actually encourage that to some extent, because I believe if someone's fighting for the animal, they deserve it. Every animal deserves to have somebody fighting for them, especially if it's an animal who, it's borderline whether it's the right thing to do to euthanize it or not, right? I love the idea of encouraging the public to fight for the life of an animal. And when you get down to the low numbers that we have, those happen. The problem was, at least in my view, is that it was a judgment call every time. And I truly do believe this here, and I know it's not true everywhere, but I truly do believe this here, that the people at the shelter are trying to do the best they can every day. And that they're trying to make the right call, to try to make a decision to balance saving every animal's life who they can, and balance the potential risks of someone being bitten by an animal with some history of a propensity of violence. And that's not an easy thing. And the fact that it is inevitable that a dog is going to get adopted from a shelter and maul someone. It's inevitable. It's going to happen, right? Because it's a numbers game when you're adopting out millions and millions of animals. We have to be mindful, I think, even as a movement, of what are the consequences of that. So what we tried to do is have a bright line rule. And we knew that some people were going to be mad about it on one side and other people were going to be mad about it on the other side. But the bright line rule we came down to was a dog with a documented history of unprovoked biting that resulted in a severe injury to a person. And so the injury had to be severe and it had to be unprovoked, meaning the animal wasn't being kicked, somebody wasn't breaking into the home of the person, and it had to be documented, meaning like we had to prove that it actually happened. Someone couldn't bring their neighbor's dog and say, yeah, it bit me. Like, it needed to be documented. There needed to be some evidence that it actually happened. And so that's where we landed, and it's going to get continued to be discussed. People are still fighting over it, as this happens, I think, anytime an ordinance is somewhat fresh. We have had a similar type of rescue right ever since we passed the no-kill plan in Austin in 2010, but it was more of a policy than a statutory right. It was, you have to give the kill list to rescue groups with the ability for them to save them. But this is the first time that we put that into actual ordinance language. Another incredibly controversial part of this, and it still baffles me that it is, but I'm sure half of the room will disagree with me. We wrote, this section also applies prior to the spay of an animal exhibiting visible signs of pregnancy unless medically necessary. Meaning that if a pregnant mom comes into our shelter, we do not want our shelter automatically spaying her. A late-term spay, I don't know if you know, is not a procedure that most people would generally support. And so what we're saying is that if there is a rescue group that wants the mom and will save the mom and the babies, that they can do so. It is not a prohibition on late-term spays. It is simply saying that if there is a rescue group willing to save the mom, that you notify that rescue group before you conduct the late-term spay. And I believe that we're the first place in the country that has that protection for pregnant moms in their animal shelter. I think we're the first place in the country. So I'm actually really proud of that because I think we should be saving. If we believe, as I do, that overpopulation is largely a myth, that we do in fact have enough homes for the animals that come into animal shelters, that our job is to increase our market share of the animals that people are already acquiring rather than killing everything that we can get our hands on. And if we believe that every life has value, which I do, and most of us do in this community, then we have to believe that mom has value and her babies have value. And if there is a group willing to save them, why on earth would we not allow them to? So it passed almost unanimously in Austin, but there were people who went and fought just that part of it. They wanted the shelter to perform late-term spays. Okay, hold period and ordinance. Let's go to the next one. Are there any questions about that one? Then this is an Austin statute that is passed, and it is law. That's right. This is an Austin law or Austin ordinance. Yeah. Sorry. Yeah. We just said it applies to prior to the spay of an animal exhibiting signs of pregnancy. So if the animal appears to be pregnant, then they have to give a rescue right. There are plenty of false positives, and I'm okay with that, where it's not actually pregnant, but they think it is. Yeah?
per town, or is it per state? Or like
California has one, Delaware has one, and then some cities have them.
okay.
Yeah.
What's the penalty for violation?
There's not a penalty written into it. It's just essentially this is the law and the shelter has to follow it. Theoretically, it would be an employment issue because all of these people are that are putting this into operation are government employees. Anything? Yep.
How does this apply to the owner's request also?
We'll get to that in a minute in the hold period ordinance, but basically in Austin, and we'll talk about it. Every animal that comes into the door, we believe we have a responsibility for. And it doesn't matter whether the owner requested it to be euthanized. We believe that every animal, we have the same duty for every animal. And there are plenty of examples of animals that get walked into euthanasia rooms that are not harmful, that are healthy, that are not suffering, because animal shelters have a policy of euthanizing every owner surrender. And we're just not going to do that. Our rule is that every animal gets treated the same, whether the owner wanted it euthanized or not. We're not a euthanasia service. You can go somewhere else for that. What we are is a place where we believe we're going to do the right thing by every animal. And if euthanasia is the right thing to do by that animal, then that's what we're going to do. But we're not going to do it simply because someone requested it. And I will tell you, there are way too many horror stories of neighbors in fights, grabbing their neighbor's pet, often cats because they go outside, taking them to a shelter and saying, this is my animal and I want it euthanized. Way too many of those horror stories. And if once you hear one of those horror stories and you're on the phone while that person is bawling because their neighbor got their animal killed, then you realize, like, we got to be out of this game of just automatically walking animals to the youth room. Any more questions about this one? Okay, all right. So the next one, and again, this is up on the app as part of this session. So you can go to the app, or this is supposed to be, let me know if it's not. Part of the app, you'll be able to download this. All right, hold period ordinances. Traditionally, again, this is kind of the theme of this of the conference is reinventing animal welfare, redefining animal sheltering, and this is one of those examples where all the old stuff is just dumb. It's like hold period ordinances were created to kill. Lots of old stuff in animal sheltering was created to kill, but hold period ordinances were created to kill. The reason they were created is because they wanted to give the government the ability to kill as fast as they could for animals that were not picked up. So traditionally they were designed to protect, except for there's a hold period just in case somebody wants the animal, right? But once that hold period is expired, it gave the authority to kill the animal, which is what its purpose was. So it was designed to protect owners in case they were going to reclaim them. It was never intended to protect animals. They do nothing to protect animals. They made it as easy to kill as possible. Traditional hold period ordinances made it as easy to kill as possible by defining the minimum wait time before euthanizing strays. Animal sheltering traditionally was just about stray dogs. That's how it started. Later it became cats in some communities. In Texas, there's still no law that requires shelters to take cats, just dogs. And there's still no law that requires a municipality to have a shelter in Texas. So there are places in Texas that don't have any. But they define the minimum, the traditional hold period ordinance defines the minimal time before euthanasia. And it allows owner surrenders to be killed immediately, which goes to your question about owner surrenders. So the traditional animal sheltering hold period encourages killing as quickly as possible. That's the whole point of it. Give the animals a little bit of time and then kill. And so we wanted to flip that on its head. Under a no-kill ideology, it's designed to protect the animals, not necessarily the owners. It's designed to make it easy to save an animal, but hard to kill it. It's designed to make euthanasia the last resort for an animal instead of the first. It delays euthanasia for all animals, including strays. And this is, again, a place where we believe we have kind of made the movement. We're defining the movement because our hold period ordinance applies to owner surrenders and strays. We have to hold an animal before euthanizing it, regardless of whether it's an owner surrender or a stray. And it enables early rescue help. Again, somewhat recently passed, and people fought it. I mean, you just not believe, people will fight you on anything. You probably, all of you probably know that. But it's like, sometimes I feel like we come up with this stuff that nobody could possibly be against. And people come up there and say that we are just horrible, wretched human beings. Like, we literally had a provision that says, and I'll get to it, that if the animal shelter is unable to provide the medical care in the hold period, and a rescue group can, the rescue group can save the animal, but it is still subject to the hold period, meaning the owner can still reclaim it during the hold period. And people fought us because they thought it would be that owners would rather us kill their animals than give them to a rescue group to save them. And people literally went and fought that. I mean, I thought it was crazy. I still don't understand it, other than when you get involved in these communities, sometimes people are just against it because you're for it. And that's just the way it happened. Okay, so bifurcated hold period. What do I mean by that? What I mean is that we have different times for different animals and different times for different outcomes. We want to make a long wait before an animal can be euthanized, subject to exceptions, and a shorter wait for an animal to be adopted or transferred to a rescue partner. And we want there to be no wait for emergencies, as I mentioned, about animals that are truly, that need immediate medical care, and a rescue group is willing to do so. We also have two more problems in Texas. One is our LIRA problem, which I talked about in my earlier session if you saw it, which is in Texas, unless your hold period and ordinance expressly says so, ownership of the animal does not transfer to either the animal shelter or the rescue organization after the hold period. So in Texas, the original owner still owns the animal, even after the hold period, even after it's been transferred to a rescue group, unless the ordinance expressly says otherwise. And it was a big case in Texas, the Lyra case, which I have here. A dog was impounded in Houston, held for beyond the hold period, then transferred to a rescue group. Prior owner found out, sued the rescue organization. I thought it was a crazy claim. They won in the trial court. It was reversed in the Court of Appeals, and then they won again at the Texas Supreme Court. In fact, holding that the previous owner, whose animal had gotten out, been held at through a hold period, and then it had gone to a rescue group, still owned the animal. And they said that that was so because the hold period ordinance didn't expressly say otherwise. In other words, they felt that the prior owner was not given notice, sufficient notice, that ownership would transfer. So we've got to deal with that here in Texas. And you might as well deal with it before it becomes a problem elsewhere. The second issue you have to deal with, let me get through this one and then we'll... Yes, we have the model that I'll get to is ours, is at City of Austin. But you could do this statewide. You could do it any way that you wanted. We also have a second problem in Texas, which everybody is going to have a little bit of a problem with too, depending on your state statute. Every state that I've seen has a Veterinary Practice Act. It is the licensing act for veterinarians. And we have one that I'll get to in a second, but every single one has one. And depending on the language of the Veterinary Practice Act, it may be, in fact, illegal for you to provide medical care for an animal. And I'll get to that. Here's our Veterinary Practice Act. The existence of a veterinarian client-patient relationship. So if you go to a doctor, you are the client and the patient, right? This is why, by the way, have you ever called your doctor and they won't help you out over the phone? They say you have to come in because you haven't been in for a year. It's because there's a similar requirement in the medical code, the state medical codes, that require you to establish a client relationship. It's why, until very recently in most states, there were no teledocs, because you would actually have to physically meet your doctor before they could prescribe anything to you. Lots of doctors are now fighting this all over the country, and that's why teledocs are allowed in Texas now, because the law was changed to allow them to establish the client-patient relationship over the phone. But previously they had to establish it in person, which is why you couldn't call someone else's doctor and get them to help you out over the phone, because you had not physically met them yet. Well, these old licensing acts also had the same thing for animals. But oddly enough, it was a step further. They had to know not only the animal, but they also had to know the animal's owner. Well, if you don't know the animal's owner, because you were an animal shelter that just took in a stray, theoretically, you would not be able to provide it with medical care. And that, in fact, in 2015 is what the Texas Veterinary Medical Board decided, that you could not provide medicine to the animal if you're at an animal shelter because you didn't know its owner. So this is what we were dealing with, and I think it was an incorrect view. I was confident that it was an incorrect view, and so we sued them, and 3 years later they gave up on the cusp of oral argument at the Austin Court of Appeals. They literally sent a letter saying, "We give up, you're right." But it was, tens of thousands of dollars in legal bills and time that went into that, and years of fighting them before they gave up on the cusp of oral argument. But everybody's likely going to have a Veterinary Practice Act. It's the licensing act for your state. And it's going to have rules with respect to when and how and under what conditions you can provide medical care without knowing the owner. Here is what we relied on and eventually won after they gave up, which was right at the beginning there was an exemption that says this chapter does not apply to the treatment or care of an animal in any manner by the owner, an employee of the owner, or a designated caretaker. In our case, it was a veterinarian of a rescue group. So she was the employee of the owner of the animal. The rescue group owned the animal because it had already gone through its hold period. She was an employee of the owner of the animal, so we said the chapter does not apply. And eventually we won. But it took us years to take on the state agency who was arguing otherwise, that essentially you could not give because you did not know the owner or the animal well enough. I mean, think about the ramifications if they were right. It would mean no vaccines, no spay-neuter, no nothing. And so fortunately they lost, but we also are dealing with that. But there's another thing to note, and again, this is these Veterinary Practice Act, it was a model act that got distributed all over the country. Some took it exactly as the model, some passed it with changes. Louisiana's, for example, says, excludes animal shelters. I think it might be governmental animal shelters. You should check if you're in Louisiana. But there are various exceptions in the acts. And ours said the treatment of an animal, it doesn't apply to the treatment or care of an animal in any manner by the owner, by the employee of the owner, or designated caretaker. And so you will see one of the things that we did in our hold period ordinance is designate the animal shelter as the designated caretaker of the animal. Therefore, we believe, and it's not been tested, that we are essentially designating ourselves as a designated caretaker under the Act. All right, so I know you can't read this, but again, it's in the app, so you don't need to know everything. You don't need to read every word with me, but I'll go through it. Disposition of an impounded. How am I doing on time? Is there a timekeeper? Okay, and I'm going to like 4. Okay, great, thank you. An animal surrendered by its owner is immediately abandoned by the owner and the property of the health authority. So we wanted to make clear, you come and surrender an animal, you are surrendering your ownership rights to that animal. We get to decide at that point what happens to it, not you. So you cannot force Austin Animal Center to euthanize an animal. You don't have that power. You surrender it to us, we get to decide what happens. The health authority may transfer, place, or sell. Sell means adopt. We just incorporated some of their old language. Transfer, place, or sell an animal surrendered to its owner, surrendered by its owner at any time after intake. Okay, so you lose ownership rights the moment you surrender it. Except as provided later, the health authority is our animal shelter, shall not euthanize an animal before the animal has been impounded for 7 business days. It was previously 72 hours before they could euthanize. That was the statute we were dealing with. And so this is really cool. We, some advocates and I came up with this, and we wanted it to be 5 days, and the Austin Animal Center said, no, we want it to be 7. Like our shelter itself wanted to make it harder, even harder to euthanize an animal. So they put it to 7 days. It they can't be impounded for 7 days. And that applies again to owner surrenders or strays. It doesn't matter what the source of, you can't euthanize it before 7 days with an exception that we get to later. Except as provided in subsection D, the health authority shall hold an impounded animal not surrendered by its owner, meaning a stray, for a period of 3 business days following impoundment for owner reclamation. On the 4th day, an impounded animal is the property of the health authority. So we now have complied with the Lyra case. which said that you must expressly state that ownership transfers. So we have the ownership transferring from the owner surrender immediately, and we have ownership transferring to the shelter upon the expiration of 3 business days. D, in order to save the life of an impounded animal not surrendered by its owner, meaning a stray, the health authority may transfer that animal. This was the one that I said was shockingly that people complained about. Only in order to save the life of the animal, the organization, the health authority may transfer that animal to a 501c3 located in the county prior to the expiration of the hold period, but it remains subject to the hold period. So if the shelter is going to kill the animal because it doesn't have the medical care for it, but a rescue group can, and this, by the way, is probably all of your bottle baby kittens, right? Most shelters, most municipal shelters are not saving bottle baby kittens. They don't have the program for it. They should, but they don't. And so this allows them to send the bottle babies immediately to a rescue group to save them. They're still subject to, they actually still have to put up their picture. Like they're still subject to the same reclamation rights. Hardly ever does it happen. But should an owner still want it, it's still subject to the reclamation rights if it goes to a rescue group within those 3 days. The health authority shall maintain documentation in physical and electronic form. We were concerned with community members that may not have access to the internet. So they're there, they should be at the shelter and on the internet. Of an animal transferred under this subsection, including a photograph of the animal. An animal transferred under this section is considered abandoned by its owner and becomes the property of the transferee organization, the rescue group, upon the expiration of 3 business days from impoundment. So again, that title transfers to the rescue group to deal with Lyra. Prior to the expiration of the period described in D2, the transferee organization is the designated caretaker of the animal. This allows us to do the medical treatment on any animal within the animal shelter. And an animal transferred under this subsection remains subject to reclamation by its owner prior to the expiration of the hold period. So if it goes to a rescue group for medical reasons, then it's still subject to the reclamation right. And again, people fought that. They thought it would be better if we killed them. I still don't get it. And these were animal welfare people that were saying, no, they should not go to rescue groups. We should either kill them or treat them. We should never allow a rescue group to save them. It doesn't make any sense to me. Going further, an animal in the custody of the health authority solely for purposes of sterilization, vaccination, and microchipping is not subject to a mandatory impoundment period. And the reason we put that in there is because we have spay-neuter clinics. We wanted to make sure that animals could go through the spay-neuter clinics. And some of them are TNR'd, right? So we wanted them to be able to come through quickly and not have to be held. The health authority and any 501c3 organization that is an animal shelter to which the health authority has transferred an animal shall not sell or transfer an animal with or without consideration. Oh, sorry, I should have explained this. I put this in here because we previously did not have anything banning animals going to labs for experimentation or veterinary schools. The animal shelter in Baton Rouge, which is my home, and I've consulted with them, and I'm embarrassed to admit this, but they work very closely with their vet school, and until even very recently, and they may still be doing it, I'm not sure, were giving rescued animals that came into the shelter to the vet school to experiment on. And what they do, I don't know if they do this, but traditionally that means like breaking a dog's leg and then allowing the students to treat it, and then euthanizing them at the end. Or labs, which of course probably do even much worse. So we just threw it in there as like banning animals who come into the shelter from being experimented upon. You can't transfer it to an organization that's going to experiment upon it. So no biological or medical testing, research, study, or experimentation can be done by animals that go through our shelter. I'm particularly proud of that. It's pretty cool to be able to say, like, you came up with the idea that your city passed to ban any animal that comes through your shelter to be ever be experimented upon. Subsections A and D do not apply to an animal that is dangerous, that's a dangerous dog. For purposes of calculating the time periods, the date of the initial impound is not counted, which is traditionally the rule. And each day of the health authority's animal shelter is open for reclamation as a business day. And so if your animal shelter is closed on Wednesday, then you don't get to count that as the day in the hold period. If it's closed on Sunday, you don't get to count that in the day of the hold period. Ours is open 7 days a week, so it's not a big deal, but part of the reason to pass this was to create a model so that others could just grab what we did and pass it, and so that's what we did. So those are our two ordinances. I know it was complicated, I know it was hard to get through, but let me answer any questions that you have on either of those two. Sure. Yep. So I don't know if everybody heard the question. The question is, if a rescue group is pulling from many shelters, how can you kind of protect yourself? I'm assuming under the LIRA problem is your main concern, right? Yeah, I mean, the first thing is you want to do is you want to read their hold period ordinance, because some of them may have already dealt with it or may accidentally already comply with it without their knowledge. The second thing is you want them to change it if they haven't. And I don't think you're going to get a lot of pushback on curing the LIRA problem. You might get pushback on them not being able to kill owner surrenders. You might get pushback on 7-day hold period. And you can, take them the model and give and take and figure out if you guys can come up with an agreement. But I don't see why anybody would have a problem with curing the LIRA problem by making sure that ownership transfers at the end of the hold period. It was literally 5 or 10 words added to their hold period ordinance that says ownership transfers at the end of the hold period, and then you're done. You're fixed. But yeah, you're gonna have to go deal with that. You're gonna have to take it to those shelters that you're pulling from the municipalities. Any more questions? Yes.
I may have missed that if I didn't make mention of it, but when you're dealing with your spay neuter clinics, your TNRs and stuff, how do you deal with that particular issue and the ownership of medics and treating some of that if you do it?
Right. So I mean, we're hoping that the designated caretaker will cure that. If it's a TNR clinic, it's a government TNR clinic. This hold period doesn't apply to nonprofits who are doing TNR on their own. Right? They may have their own issues with the Licensing Act. But as far as an animal that comes into our shelters program to do TNR, then we believe, hasn't been tested, so we're not 100% sure, that we can declare that veterinarian a designated caretaker for the animal and therefore provide. Right. Now, I would not advise doing, unless you have some kind of exception, I would not advise doing, TNR is a different animal. I would not advise doing spay or neuter on an animal during a hold period, generally, right? Because that animal is not yours yet. And an animal that it might be a breeding animal or a show animal, you may in fact be devaluing the animal. Sure.
When you have owner turn-ins, do you have require proof of ownership?
I'm not sure if they do. I don't know. I'd have to ask somebody at the shelter. Yeah. I mean, anybody can take a picture of an animal and say, see, it was mine. So I'm not sure. But either way, I mean, our goal is to treat every animal the same. But you're right. I guess theoretically, if an owner lies to them and says, I'm surrendering it, and it was really a neighbor's animal, it could get adopted out quickly, even though it could not be euthanized.
Right. Not necessarily, but yeah.
Right. It could be. Yep. Anybody? Any other questions? Yeah, sure.
I missed like one word when you just described about a funeral organization, nonprofit.
Yeah.
Is that as a designated caretaker? Is this something that's really
Yeah. So this ordinance only applies to the animal shelter, right? So we believe that we can comply with the Veterinary Practice Act by designating our animal shelter veterinarians as essentially designated caretakers of the animals that come through our system. If you are a nonprofit doing spay-neuter and you don't know who the animal's owner is, you may have issues that you need to worry about with the Veterinary Practice Act. That's all. That's as far as I'm willing to say it, but that's something you should know about.
Couldn't they reasonably presume that the person that brought the cat to them was the designated caretaker making those?
That is an argument that they could make to a court. Yes. Any other questions? All right, thank you guys for suffering this presentation.